Please be seated. The court is now back in session. And the chamber would like to give the floor now to civil party lead co-lawyers. You may proceed.
Thank you, Mr. President. Good afternoon, Your Honors. Good afternoon to everyone in and around the courtroom. My name is Beini Ye. I am one of the international civil party lawyers. I am here today to speak on behalf of Elisabeth Simone-Faure, the international lead co-lawyer who cannot be present today. I would like to present the responses of the civil parties on the scope of case 002/02. First, I would like to talk on the submission of Khieu Samphan's defense counsels on the scope of the subsequent sub-trial. The defense counsels for Khieu Samphan request that all of the remaining factual allegations and crime sites of case 002 should be included. This is equivalent to refraining from issuing any further severance decision. The civil parties do not support this request. In the appeal decision on the second severance order, the Supreme Court calls on the trial chamber to balance different legitimate interests when making the decision on whether or not to sever the case. This is in paragraph 37 of the decision. In doing so, the trial chamber's discretion remains broad, as outlined by the Supreme Court in paragraph 51 of the decision. Now, from the perspective of the civil parties' interests, such a balancing exercise leads to the conclusion that a further severance of the remainder of case 002 is necessary. At this stage of the trial, the civil parties have two major interests. First, the consolidated group of civil parties has an interest in the education of all charges in the closing order for case 002 in order to hold the accused accountable for the wide range of crimes and reflect the diverse harms suffered by the civil parties. Secondly, at the same time, the civil parties seek for judgments to be issued as soon as possible because they have the right to see justice done within their lifespan. As my colleague pointed out this morning, many civil parties are elderly and their health is deteriorating. Many have already passed away in the course of these proceedings. These two interests need to be balanced against each other because the adjudication of all remaining factual allegations in case 002 will certainly prolong the wait for a judgment on the remaining charges. A balance of these two interests can be achieved by severing the remainder of case 002 and including a reasonable representative segment of factual allegations and crime sites in the next sub-trial. This would allow the court to adjudicate a significant portion of the remainder of case 002, a portion that reflects the wide range of crimes and diverse harms suffered by the civil parties, and at the same time issue a judgment on them within the lifespan of most civil parties. Therefore, the civil parties do not agree with the requests made by the defense of Khieu Samphan, but rather request to sever the remainder of case 002 and include the crime sites and factual allegations as set out in our submission on the scope of case 002/2, document number E301/5/3. I come to the submissions of Nuon Chia's defense counsels. In their written and oral submissions, defense counsels for Nuon Chia request a more lenient admission of evidence outside the case 00 closing order. Defense counsels also claim that S21 is not representative of case 002. The civil parties would like to make two observations on these submissions. First, on the issue of admitting evidence beyond the closing order, we do not deem this argument to be relevant to determine the scope of the subsequent case. Internal Rule 87 requires a case-by-case assessment of the relevance of evidence. A blanket ruling admitting, and I quote, any evidence on any subject within the scope of the case 002 closing order, end of quote, as requested by the defense in their written submission, is therefore not an option. On the question whether S21 is representative of Case 002, we would like simply to point to the Supreme Court's binding order to include S21 in the subsequent sub-trial, as set out in the appeal decision on the second severance order in paragraph 76. I have no further observations to make or responses to make on this point, and I thank you for your attention.
Thank you. What about the national lead co-lawyer? Mr. President, I do not have anything else to add through my colleague's statement. What Benye arrest is a representative of the entire team. President, thank you. We would like now to give the floor to the co-prosecutors. You may proceed.
Thank you, Mr. President. Thank you, Your Honors. In reading the submissions of the various parties and listening to the oral submissions today, I believe there's one area where all agree, and it's important, I believe, to stress that. And that is in deciding upon the scope of this victims and of the accused means that these trials cannot keep going on forever. In addition, it's necessary because this is an extraordinary chamber. It's a temporary court. And all expect us to have a strategy to complete our work. And in regards to case 0202, this obviously is now in the hands of Your Honors to develop that strategy of how we can try the remaining charges, the important remaining charges, in a reasonable period of time and complete our work within the lifetime, of course, of the accused and of the many victims awaiting for justice. The submission that the prosecution made back in December, and we stick with that, is that we can deal in this trial. It is reasonable to believe that we can deal in this trial with all charges, all remaining legal charges not covered in case 0201. We can do that, we've argued, by streamlining the case and reducing the number of crime sites, the number of individual crimes that are dealt with in the trial. As you know, we've even given a list of proposed witnesses that we believe would cover the charges. That comes out to less than 100 days, with the understanding, 100 court days, with the understanding that, of course, additional witnesses will be proposed by the other parties. It's critical to those outside trying to understand how is it possible to efficiently do this trial in a reasonable period of time. We've said a year and a half, when the first trial took a year and a half. The answer to that was very importantly based on the decision Your Honors gave last Friday, the clarification, where you clarified that all of your previous statements, you reiterated, the trial in case 0201 will be the foundation for the trial in 0202. The evidence in any war crimes court of senior leadership, the evidence that is most time-consuming and the most difficult, is always the evidence regarding the linkage of that person to the policies and the crimes. What was their position? What was their power? How did they contribute to the enterprise, to the crimes that occurred? Most of that evidence has already been heard in case 0201. It's already on the record. So when we say this will take an additional year and a half, the trial really began with the trial of case 0201. Most of that evidence is highly relevant to the charges in case 0202, and Your Honors will be able to consider that. Now, the Nunchia defense has raised the issue today that, well, there may not be much left for the defense to argue because Your Honors made certain findings about crimes that happened at S21 in the first trial before this court, the trial of Duik. And in the trial 0201, we all expect certain findings about the role and responsibilities and leadership of Nunchia, what his powers were, and contributions to criminal plan in democratic Kampuchea. The defense seems to approach this trial as if it is, frankly, a sporting event where it's Your Honor's role to make sure that both sides have an equal chance to win the game. But this is not a game. The fact that there were findings that crimes occurred, the fact that there were findings based on law and evidence about the role of the accused, does not mean in any way that there's a bias on the part of Your Honors. It does not mean in any way that Nunchia does not have the right to challenge whatever he can challenge in the subsequent trial. It's not up to Your Honors to tell the defense what lines of defense are left. It's up for the defense to figure that out. And if, in fact, the case is so strong that there is no defense, well, that means justice will be done. Obviously, we have very talented counsel on the defense, and I'm absolutely positive that they will come up with arguments, and they will argue the best for their client, and we will face a very tough battle in case 0202. The defense, in talking about S21, seems to hold over Your Honors the possibility that there will be a motion, or the probability that there will be a motion to recuse Your Honors from this case. And today, they said, on the basis of findings in case 01, the trial against Duik. And my response to that is, first, this is extremely late to be talking even about a motion of recusal when the Duik judgment was issued years ago. And there's a responsibility of any party that sees a bias on the part of a judge to bring that to the attention of the chamber and make such a motion immediately. But more importantly, this is an issue that's already been adjudicated. Such a motion, on exactly the same basis, has previously been filed. It was filed on behalf of Ing Tarith. And in that motion filed, I believe it was in the decision on the motion by the judges who were assigned to hear the decision, they cited numerous cases from international tribunals that hold that the fact that judges hear cases with related facts does not disqualify them in hearing a subsequent trial that involves the same factual scenario. That also has been dealt with in other tribunals. For example, fairly recently, in the International Criminal Tribunal for the former Yugoslavia, not that recently, but on the Karadzic case that's ongoing, there was a motion filed back in 2009 and a decision on the 22nd of July, 2009. In paragraph 24, it's mentioned that the tribunal, that is the ICTY, has already on several occasions confirmed that its judges are not disqualified from hearing a case by having dealt with witnesses or evidence related to the same facts in other cases. So that's the general principle. The specific challenge based upon Your Honor's participation in the judgment of Duik has already been heard, so there's no basis not to include S21 in the scope of case 0202. it's very understandable why the defense of Nuon Chea would not want S-21 included. But in our view, it's essential to understand what was happening in democratic Kampuchea to include S-21. And further, it's mandatory. We have a Supreme Court decision that has already outlined the minimum charges that will need to be heard in order to make 0202 representative. In our view, the case will be representative by dealing with all charges, even if not all crime sites. And we believe that satisfies the needs of the victims because of the very special circumstances of this court, which makes this case and this court different from other cases in other civil law jurisdictions and ordinary domestic jurisdictions, including in Cambodian courts. There is the principle, I believe it's called the principle of legality. We all know that normally in civil law courts, judges, trial chambers must deal with all of the crimes charged in a closing order. So if there are 3 murders charged in a closing order, all 3 have to be dealt with. That apparently, I understand, is the normal procedure in the domestic courts of Cambodia. It's not true of all domestic systems, and I'd like to just mention one matter that was raised in the Nuon Chea filing, where they talked about the German Procedure Code. It's Section 154. This was also mentioned in the Supreme Court decision on severance. And in Nuon Chea's filing, they said that this only dealt with insignificant charges. Thank you. In fact, the commentary for Section 154, there's a commentary that's very respected, I understand, in Germany by Diemer, D-I-E-M-E-R. And in his commentary on Section 154, it states that while that section says charges not particularly significant violations of law can be relatively, Diemer explains that when 154 talks about, it may be necessary for me to read 154 so as not to confuse everyone. 154A of the German Code says, if individual severable parts of an offense of some or several violations of law committed as a result of the same offense are not particularly significant, in addition to a penalty, paragraph 2, or measure of reform and prevention which has been imposed with binding effect upon the accused for another offense, that it's then possible for the prosecution to drop that charge. Diemer explains that not particularly significant violations of law can be relatively important violations of law. The crime of murder under specific aggravating circumstances, according to Section 211, is not particularly significant when the accused is sentenced to life imprisonment for attempted murder. So different systems have different ways of dealing with the fact that it's inefficient and maybe a poor use of judicial resources to try cases over and over again when the penalty will not be increased. In the current case, we're dealing with a very particular set of circumstances. We don't have 3 murders. We're dealing with thousands, tens of thousands, millions of victims of the various crimes charged in the closing order. It obviously would not be possible to deal with the individual crimes against each of those individuals. And this chamber and this court has already recognized that the normal civil law system must be adjusted to deal with this reality. And it's been adjusted already in discussing how victims can participate. You'll recall that the pretrial chamber admitted thousands of victims whose crimes, as I understand it, were not mentioned in the closing order on the basis that the crimes that they were victims of were, in the closing order, accused of being nationwide policies. And Your Honors have also adopted the same procedures. So, in E145, a decision on severance and reparations, Your Honor said on page 2, in the second full paragraph, the Chamber in its severance order, E124, clarified that as, quote, under the applicable legal framework, civil parties no longer participate individually on the basis of their particular harm suffered, unquote, and that, quote, limiting the scope of facts to be tried during the first trial accordingly has no impact on the nature of civil party participation at trial. So that is why, in our view, limiting the crime sites to those sites that are representative of what occurred in democratic Kampuchea will ensure that victims of these crimes that happen all over the country, in whatever sites, whether named in the closing order or not named in the closing order, will receive a measure of justice. Because it's already been ruled in this court that they can participate in these proceedings and that there is no individual reparations. The reparations don't occur on an individual basis. Now, one of the factors undoubtedly in your decision on the scope of this charge, on defining the scope of the charges to be heard in case 0202, is going to be when can we complete this trial? And it's been highlighted already today that there are two issues that are looming before us that will affect the proceedings in this case, the timely proceedings in this case. One is, the defense has already mentioned again in their filings for Nunchia and here in court, the probability that there will be motions to disqualify. We can start dealing, or Your Honors can start preparing for that. Obviously, that is a motion under the rules that must be heard by other judges. It should not delay the proceedings. Secondly, the appeal is looming. Once the judgment is issued, which Your Honors have indicated will be in the second quarter of this year, the appeal is looming, and all parties will be under deadlines to make written submissions in that appeal. It doesn't take a mind reader to anticipate that there's going to be filings by parties to extend their time to file the appeal submissions and to object to being full-time, doing the trial and doing the appeal. So even after we have the trial judgment, the court is going to have to balance the fact that parties are going to be engaged in the appeal and hopefully the trial of 0202. Mr. President, in your memorandum rejecting the second trial chamber, you stated that you were still considering and would consider the possibility of beginning the trial on a limited basis, in other words, a few days a week, while the judgment writing is continuing. We would, again, urge you to do so because there is no good time to begin this case. If we wait for the judgment, then we face the disqualification, then we face the appeal. The appeal submissions and appeal arguments will certainly take us at least through the end of this year. What we've all seen with the international courts is that there's momentum. When proceedings begin, they've always been completed. Any tribunal that has begun a case has been funded and has completed that case. We think it's important to start that ball rolling. As difficult as the job is, it's easier to move an object in motion than an object that's static. So again, thank you, Your Honor, for listening to us. The prosecution submits that the scope of case 0202 should cover all legal charges. We've outlined in our written submissions the locations where those particular charges can be dealt with. We believe it can be dealt with within a year and a half of evidence. Thank you.
President, thank you, Mr. Prosecutor. The hearing of the parties' responses on the scope of case 02/02 has now concluded, and for the benefit of fostering a greater understanding of the legal process, the Chamber wishes to briefly inform the public about the steps taken so far, as well as the next steps which must be completed before the evidentiary hearings in case 002/02 can commence. On 7 February 2014, the Chamber disposed of the co-prosecutor's request regarding the use of evidence from case 002/01 in case 002/02. The Chamber indicated that proceedings in case 002/02 are a continuation of those in case 002/01. The evidence put before the Chamber in case 002/01 has undergone extensive examination by the parties and has been subject to the requirements of Internal Rule 87. Based on the foregoing, the Chamber reiterated that the case 002 case file remains the same for both phases of the trial, and the evidence already put before the Chamber in case 002/01 shall serve as a foundation for case 002/02. As to the recall of witnesses, civil parties, and experts who testified in case 002/01, the trial chamber indicated that it will consider whether the parties were prevented or did not have an opportunity to fully examine an individual they intend to recall in court because of the limited scope of case 002/01. The trial chamber has now received written and oral submissions from the parties on what charges should be included in case 002/02 and will issue a decision on the scope of case 002/02 as soon as possible. The Chamber will also make a decision on Khieu Samporn's request to not commence evidentiary hearings until a final judgment has been issued in case 002/01. Furthermore, the Chamber has received written submissions from the parties on the status of the health of the accused, and it will soon decide if there is a need to assess the health condition of the accused. Once the Chamber has addressed these issues, The parties will be invited to file list of the witnesses, civil parties, and experts they intend to call for questioning during trial, as well as the documents they seek admitted as evidence. Thereafter, as indicated in its work plan for case 002/02 issued in December 2013, the Chamber will schedule an initial hearing. This concludes today's adversarial hearing. As the President of the Trial Chamber and on behalf of the bench, I thank the parties for their input. And on behalf of the Trial Chamber, I thank the prosecutors, deputy prosecutors, the defense lawyers for the accused, the civil party lawyers, and the lead co-lawyers for civil parties, the officers of the Trial Chamber, and all officers under the Office of Administration and the security staff, as well as the interpreters who strive their efforts to make this hearing smooth and functional. And I now declare the conclusion of today's hearing. Security guards, you are now instructed to take the accused, Kyu Sompon, to the detention facility. The hearing is now adjourned.